All right, we're going to switch gears and we're going to focus on the police cover-up trial. Yesterday was a dramatic day, not only because the defense lost their bids in order to have this case thrown out, because the trial will continue. The judge ruled against them. But it was also discovered that it was also laid out by the judge that numerous emails will be allowed into evidence. We're going to talk about that in a minute. But before we do, if you don't know anything about this trial, you want a quick recap, here's a short report explaining a little bit more about it.
3 Chicago police officers are facing obstruction of justice and conspiracy charges for reportedly lying about the shooting death of a black teenager. Prosecutors say former Detective David March, Officer Thomas Gaffney, and former officer Joseph Walsh intentionally attempted to conceal the facts of the killing of 17-year-old Laquan McDonald. Laquan was shot and killed by the trio's colleague, Jason Van Dyke. Van Dyke was indicted in 2015 for shooting the victim 16 times. He took the stand in his trial and claimed that he shot because the victim, who was holding a knife, was coming towards him.
What was Laquan McDonald doing?
Advancing on me.
And did you say anything to Laquan McDonald?
I was yelling at him, drop the knife. I yelled, I don't know how many times, but that's all I yelled.
And did he keep advancing toward you?
He never stopped. He waved the knife from his lower right side upwards, across his body, towards my left shoulder.
And when he did that, what did you do, officer?
I shot him.
But some state witnesses had a different story.
Before you see him fall, did you see him raise his arm as if he was attempting to stab anyone?
No.
Did you see him attack anyone?
No.
Did you see him walk, run, or charge at any officers?
No.
Van Dyke was found guilty in October of second-degree murder and 1 count of aggravated battery for each of the 16 shots. He was acquitted of official misconduct. Court documents accuse March, Walsh, and Gaffney of a medley of crimes, including mischaracterizing video recordings, creating false police reports, and failing to report false information in order to protect themselves and Van Dyke. The indictment claims that Walsh, Gaffney, and another unknown person reported they were victims of McDonald, and another unnamed person was injured by the offender. That claim was allegedly reviewed and submitted by Detective March. It also says a reported false claim attributed to Officer Walsh stated that the victim attempted to get back up after being shot while still holding the knife. Claims that the video evidence of the shooting does not support. All of the officers entered a not guilty plea to the charges. For Law and Crime, I'm Rachel Stockman.
Thanks, Rachel. So where are we in the case right now? It's dark today. It's coming back tomorrow. The judge refused to throw out the case as the defense attorneys would want. And we also learned at the beginning of the day that the prosecution has officially rested their case since the judge ruled in their favor to allow key pieces of evidence, particularly all of these email exchanges between Chicago Police Department supervisors. The prosecution wanted that evidence in to show this conspiracy, but I want to get some reaction right now from our very special guest, a familiar face here on the network, one of our hosts, juvenile judge, as well attorney, a trial attorney, and also host here on the network, Judge Ashley Willcott is with us. Ashley, great to see you.
Good morning, Jesse.
Let's start with the emails. All those emails were allowed in. What did you make of them?
Well, so here's what's interesting. The emails are not between the 3 defendants, as you just pointed out. So it's nothing that was emailed to or from the 3 defendants. Instead, it involves, as you pointed out, the supervisors. And so I think that there was some question as to whether or not the judge would allow it. But I think in a conspiracy trial to cover up, it's absolutely relevant to these particular charges.
I mean, in one email, an officer writes, "Any luck making this case go away?"
Right. They're pretty damning. And without these emails, Jesse, I think the prosecution would not have been able to win this case. Now they stand a chance.
It's hard to know which way the judge is going to be siding one way or another, but by allowing these emails in and by not granting those directed verdicts to throw the case out, it seems to suggest that she says, well, there's at least enough evidence here to show some of these charges, to show the prosecution has met their burden for some of these charges, but there's a long way to go. Ashley, stand by. I want to play some testimony that our viewers might have missed. So we saw the testimony of Steve Maris in Information Services from Chicago Police Department. This is, again, about, he's kind of like the records guy. Let's play some of that testimony because it's really important, and it is particularly about these emails. Okay, so one of the things that we learned about, Ashley, in these emails was that the officer's safety became a concern because it was made public who they were. And this was a very, and all the video was released of the shooting. This became a really interesting discussion and analysis of how the police department and the city was trying to protect these officers.
Absolutely, and that's their job first and foremost, is to take care of their own officers, which is what they were trying to do.
And let me ask you this, though. Really, the idea here that the judge allowed these emails to come forward, I said before that seems to suggest that perhaps she believes there's enough evidence of a conspiracy. I mean, why else would she allow them in? What do you think?
Well, I don't think that she has the ability as the judge at this point in time to make any conclusions of facts and based on the law because she doesn't have everything in front of her. Instead, a judge, as myself, has to go piece by piece and say at this juncture, is this evidence that the rules of evidence allows to come in for me to even consider? And her decision was yes, absolutely. Now remember, Jesse, they're saying exactly who did write the emails, who they were written to. So the defense can always call those particular individuals for purposes of cross-examination.
And that maybe will happen when the case starts up again tomorrow. Let's take a quick break, though. We have a lot more to talk about. Okay, we're getting a sense of these emails. Ashley, what do you think about what you just heard in terms of the first response from the Chicago Police Department in relation to the Laquan McDonald shooting?
Well, part of that testimony was they're going to dig into those emails once they were getting back and able to do that in this particular case, or dig into the case. And Jesse, it sounds damning in and of itself, but I think what's key is to hear what the prosecution presents in terms of all of the emails and the big picture that that paints.
One of the emails that really stood out was, offender chose his fate, possibly suicide by police. We are trained to shoot until the threat is eliminated, defeated, or neutralized. Officer did exactly what he was trained to do. What do you think?
Well, here's the problem with that, Jesse, is you have the eyewitness who's testified in this case, and you have a video where the victim was down, had been shot, so the threat was arguably eliminated, but the shots continued and continued and continued even when he was laying on the ground. So that what's portrayed and what you just stated is not consistent, arguably, with the eyewitness and the video. And
you can imagine why the defense didn't want these emails put into evidence for precisely this reason. Let's continue on with Steve Maris. Big day for the prosecution as those emails were read into evidence. Ashley, I got to ask you, all three defense attorneys made arguments for a directed verdict. They wanted the case thrown out. It wasn't thrown out. Now, we'll talk about all the different reasons why that may be, but is one of the reasons, if these emails were not put into evidence, do you think that they might have had a better shot at maybe getting some of the counts, if not all, dismissed?
Not necessarily, because I think, remember, for directed verdict, the judge has to find specifically that there's no legally sufficient evidentiary issues before the court. And there's been other testimony, other evidence that it is enough for a court to consider. So I don't think that emails would have caused a different directed verdict whether or not they were let in. I do think, Jesse, the emails will make a huge difference in what this judge decides in terms of any convictions.
But just to explain to our viewers, just because the judge, and the judge, this is a bench trial, she's going to ultimately determine their fate, whether not guilty or guilty on any of these charges, just because she ruled against the directed verdict doesn't mean she's going to vote in favor of guilty later on.
Absolutely, and often a directed verdict is made by the defense. That's kind of a standard tool for the defense to have in their lunchbox, so to speak. It's not the right anyways. But in this particular case, she denied it. They almost always deny it. Judges almost always deny it because typically the prosecution has presented some kind of evidence that's sufficient to continue with the trial.
As we read these emails, and they're coming into evidence, yes, you're getting the sense that there was a sense to protect Van Dyke. But is that necessarily illegal or improper that the police department was trying to see how they could help Van Dyke? I mean, if they were trying to cover up facts, if they were trying to throw pieces of evidence out, sure. But just trying to find arguments to best support him, or, you know, try to see how the manual of might help him, or see these different ways, is that necessarily wrong from what we're reading?
Absolutely not. It's not illegal. It's not wrong. And that's part of the challenge for the prosecution, is to show, because all police are going to respond and say, I'm going to dig into it when I get back, and we're going to look at what happened, and we're going to look at articles about what type of shooting is appropriate and what's not. That's normal course of business when there's a police shooting. What the prosecution has to do, Jesse, is show that there was an actual conspiracy to cover it up, that it went beyond typical, we're looking at a police shooting and we are going to protect our own, to we're not looking at the facts, we're lying about the facts, or covering up facts to protect that officer.
Yeah, there is a difference there. Ash, stand by. We're going to take a break. When we come back, we're going to switch gears and talk about Robert Mueller's sentencing memo in relation to Michael Flynn. We'll be right back. So that's Bradley Edwards speaking out after this settlement announcement with him and Jeffrey Epstein. I'm back here with Judge Ashley Willcott. So what they're talking about right now is there's a second lawsuit going on about the federal crime victims' rights suit. And basically what it attempts to do is to invalidate that non-prosecution agreement, throw out Epstein's non-prosecution agreement. If he's out into the open, the question is, would charges be brought against him? But at least, at the very least, these victims would then have to be spoken to. They'd have to be investigated. I'm curious your thoughts about the likelihood of that lawsuit actually working, being successful.
You know, I think that it could be successful. The problem is, even if it's successful, I do not believe that anyone's going to prosecute this case. The failure to prosecute in the first place and really give this defendant a sweetheart deal, I mean, come on, you don't charge someone with soliciting prostitution when it's an underage victim, because the prostitution, no underage victim can be a prostitute. So I think that even if it were successful, they're absolutely right. There would not be a subsequent prosecution
of Mr. Epstein. So maybe. Let's continue on with the press conference from yesterday. You can watch the rest of that interview, of course, on lawandcrime.com. But Ashley, he denied this throughout the whole interview. Said doesn't even know her. He said that he helped Jeffrey Epstein in his criminal case, but he's not a current advisor to him, but kept on denying this, and even said if she were to come forward and come on our show and make an accusation, he would turn around and file a lawsuit against her for defamation. What are your thoughts on that?
Well, he's threatening her, first of all, because, you know, he does continue to deny it. This is not the first interview in which he's denied it. He has consistently denied it. Here's my caution. We've seen other individuals deny knowledge, and then we have certainly learned that they did have knowledge, and more than just a casual acquaintance knowledge. So, Jesse, I think the concern I have is it's not okay for a victim to come forward and the person they've accused just threaten and blatantly say to the public, to everybody, fine, I'm going to slap a lawsuit on you to shut you up. There should be an investigation of the victim's allegations.
So you're saying if he really believes, if he's really saying this is a complete fabrication, allow an investigation, see the truth, but he shouldn't be threatening her with legal action.
Absolutely. And if he's being honest and sincere that he has no knowledge of this individual, there's no reason to say there shouldn't be an investigation. In
other words, in your opinion, the strategy that he's been taking and what he's been saying might indicate something else.
Well, absolutely, absolutely. And it's just threatening and using your power, and I don't think it's a good, smart, appropriate tactic.
Let's talk about Alexander Acosta. He was in charge of making this plea deal happen. He says he was pressured by the defense team for Jeffrey Epstein into making this deal happen. My question to that is, and now he's a high-level cabinet official, my question to you is, what? Can you explain that to me?
No, I can't explain it to you, and it kind of makes me it just makes me sick to hear all of the circumstances around this, because as an attorney, especially one working for the government, protecting the people, prosecuting crimes, you should never, ever feel pressured, quote unquote, by the defense. Your job is to prosecute, to be reasonable, to apply the facts to the law, to make people responsible for the crimes that there's evidence to support they committed. It is not to say, oh, well, I gave him a better deal because defense made me feel bad or pressured me. you're in the wrong job if that's what defense attorneys are capable of doing.
And there was another question about whether, Epstein helping in other investigations at that time. Remember, it was during the subprime mortgage crisis, and he definitely provided some valuable information in other criminal investigations. So it's a question about how this all happened. And, this is a very interesting case, and we're going to talk more about it. Ashley, I want you to stand by. We're going to come back. We're going to focus our attention, though, back on the police cover-up trial out of Chicago, Illinois, because we will be back live in that courtroom tomorrow. We're coming towards the end of this case, and it's going to be very interesting to see which way it will go. So stay tuned here on Law and Crime. We'll be right back. Okay, so that was some cross-examination by James McKay, the defense attorney for David March. And I want to break down what he was trying to argue right there with Judge Ashley Willcott, who's back with us. So what he keeps saying, and he made this argument in his motion for a directed verdict, my client, if he wanted to cover stuff up, he would have taken that video of Laquan McDonald and thrown it in Lake Michigan. He's kind of arguing the same thing, how David March kept having control and custody over key pieces of evidence. Is that an effective argument?
Well, I think that combined with the other half of his argument, which is March was never involved in any of these emails. March never sent an email, and you would have seen it if he had, because your division has all the emails that said anything to indicate he was trying to conspire, he was trying to cover up, that he was lying in his statements. So those two arguments together potentially can be very effective. And Jesse, the thing I think we all have to keep in mind at the beginning of any investigation, especially a police shooting investigation, it is sheer chaos, and people are talking and saying, oh, I saw this and I saw that and this is my perception, and all of these things get translated and sent in, and then the emails start flying. And so I just think that we don't yet have the complete picture, but I think it's the only defense they can argue, and it might be successful.
But there's a counter argument here that the prosecution, they might have shown a little bit of something was a bit iffy, a little eerie, but is it enough to show a conspiracy? Is it enough to show obstruction of justice? I'm curious your thoughts of that argument, because we were wondering, there's been a lot of comments that we've seen online and people saying that, you know what, I just don't think the prosecution has met their burden yet. I don't see much of a case. What would you say to that? I don't
think they've met their burden yet is what's key. They have a lot of dots that they're going to have to connect, Jesse. And if they do that by the end of their case...
Well, the prosecution rested their case.
That's right. They did. That's right. I apologize. I forgot that they did rest after the witness. So I think that that's the problem. Now that they've presented all that evidence, in closing argument, they're going to have to connect the dots in a more significant way to convince the judge this evidence shows that they conspired and did cover up. But they still have that last step of really connecting all the dots for the judge.
Yeah, that might be what they do under cross-examination of the defense's witnesses and in their closing argument. A lot more to cover here on this trial and a lot more to talk about. Let's take a quick break. We'll be right back. Okay, so I'm back here with Judge Ashley Willcott. Now, Ashley, we're seeing these arguments by the defense, and one of the things they say is, look, this is hearsay. You're going to make a trial out of a trial in this if you get all these emails in. And I'm curious your perspective when you heard this. There was a part of me that thought, well, maybe they have a point. If these emails they're not even written by the defendants, they're not sent to the defendants, why are they even coming in?
So they are hearsay, but it can be included and admissible under exceptions to hearsay. So, for instance, a business records exception, and that's why you saw the prosecution have someone authenticate these emails and have them introduced into evidence. So I do believe that they could be admissible or admissible, which is what the judge found under the rules of evidence. What this means, though, is what they also argued by one of the defendant's attorneys right there, which is now there's a bigger, greater burden. It's very burdensome on the defense, because now that these have been admitted, they have to actually go back, pull police reports, and determine which of those individuals they want to call as witnesses to cross-examine. And so they have even a bigger job now of trying to figure out what do we present in response to the judge allowing those into evidence. One
of the arguments that they said was it's like you're forcing us to be the prosecutors and prosecuting Laquan McDonald as being the attacker that night.
Well, I mean, they are... I don't agree with that. So that one's a hard one for me to buy. But
that crosses the line for Judge Ashley Willcott.
It did. That's just what I think. I don't think that's a reasonable defense. But they have an obligation to represent their clients and present all the defenses that they can, right? And I do think that they're doing that zealously, which is their responsibility.
Okay, let's see how the prosecution responded to these arguments, because, as you know, they wanted that evidence in trial. Take a look.
Your Honor, these exhibits are directly in response to the cross-examination of Sergeant Snelling with regard to TRR reports and OBR reports, and the cross-examination of whether or not they are confusing or how boxes are supposed to be checked. It is in response to that we would offer these exhibits for the state of mind of these individual defendants and against only their defendants. To say that they know nothing about these incidents is remarkable, in that these reports are supposed to and do describe exactly what was happening in these incidents. As you heard the testimony of Sergeant Snelling, the TRRs describe what the subject's actions were and the members' response, why they responded as they did. The OBRs describe the battery and or the assault on the officers and the circumstances of it. So these are statements, party admissions by these individual officers regarding these incidents, and it tells you all about the incident. Mr. Gaffney's incident tells you that it tells you the date, tells you the place, says that the offender did not follow verbal directions and that there was an imminent threat of battery. And it says exactly what the member's response was, that he gave verbal commands, that he was present, and that there was a takedown, an emergency cuffing. And if you couple that with the OBR, you know what happened. The OBR says that he was on duty with one partner and that there were two officers who were battered, as we all discussed, that it is apparently interpreted as battered or assaulted, and that there were verbal threats. And then it says, looking down, a type of weapon threat, firearm caliber, a 9mm semi-automatic weapon, and it says officer at gunpoint.
Okay, so back here with Judge Ashley Willcott, do you ever notice that in a lot of the trials that we cover, I start wondering, I'm like, why do people keep putting things in writing that you know can come back to haunt them? I mean, we talked a little bit about this, how there was at least one email where they said it seemed like Laquan McDonald was trying to commit suicide, death by cop. And then there was another email where it basically came in and said, well, this will help Van Dyke's case, right? Do people just not realize that this could come back to haunt them?
I don't think that they do. I think human nature is just to act and react. And we, at this day and age, technology, we all know, Jesse, we email everything or text or whatever format, and it's in writing. And I don't think they thought ahead to say, hey, what if we get charged with a crime and it's going to be used against us? Criminals aren't smart. This happens all the time, and it's used against them.
That is why I have resorted to carrier pigeons. I feel that's a great way to communicate with people, but it's just not taking on the way that I want. Let's take a quick break. When we come back, we'll talk more about this case and more about Jeffrey Epstein a little bit later. We'll be right back. Okay, I'm back here with Judge Ashley Willcott to talk about this. My question to you is, as we listen to, the arguments made for have the evidence put in, a lot of these emails were being read. Did you ever get the idea, well, were other people charged in this crime? I mean, were there other people that might be brought up on charges? I mean, there seems to be some curious questions being asked of supervisors at the Chicago Police Department. So in other words, however this trial ends up, you think that's the end for the Chicago Police Department in relation to the Laquan McDonald shooting?
I do, and here's the reason, because although they talk about the other supervisors in those emails, Jesse, those descriptions are about things that they had either been told or were reported to them. So I don't think they're going to charge anyone else. I also think, here's my prediction, if there are any convictions in this particular case, I expect to see an appeal about the very issue of whether or not the judge should allow these emails in.
You think it's that important of an issue that happened yesterday? Because the defense was making some important arguments, but so was the prosecution.
Absolutely, but they're using it, the prosecution, as a statement against party interest by a party, but it wasn't by a party, it was by other third parties, not these defendants. So,
so what you're saying is because the defendants didn't write the emails and it wasn't sent to them, right?
Right.
Gosh, I just blur of law school right there. Yeah.
Right. Good translation. Yes, that's exactly what I mean. I think it's a good appealable issue.
Okay. Well, let's see what the defense argued. This is the defense for Joseph Walsh. And again, this is one of the arguments that was made in saying that this evidence should not be admitted. All right. That was one of the defense arguments for why some evidence should not be admitted yesterday. And these emails that were ultimately allowed in, pretty strong for the prosecution's case. Ashley, one of the things that we saw yesterday was the arguments between the defense and the prosecution about whether or not this case should end right now. The defense was saying the prosecution just has not met their burden. One of the interesting arguments that kept being made was that the prosecution failed to show intent. And how do you show the difference between a mistake in the reporting and intending to mislead and falsify? And I thought that was an interesting argument because the question is, in your opinion, based upon what you've seen in this case, what establishes intent?
Well, I think that exactly what they've allegedly done to cover it up, you can assume is the wrong word, but you can presume there was intent. Here's what I mean by that. They said that the victim who was shot, Laquan McDonald, attacked officers, that there was battery on 2 officers by that defendant, and there were injuries to those 2 officers or marks on those 2 officers because of that battery. If they can establish beyond a reasonable doubt that that never occurred, I think a judge can take from that a presumption that there was clearly intent because they just made that up. There's no evidence at all it occurred, the batteries. They must have intended to make it up.
What about the idea that their statements that they made had very similar language, almost identical language?
You know, I have 2 theories. One is, did they conspire to use that language? The other is, as we all know who are in the field and hear trials and put trials before judges, law enforcement has certain specific language that they tend to use in writing their reports. And so a lot of times police reports read in a very similar fashion, even though they're by different officers, because of that training. So I think that's one thing to consider.
And let's play devil's advocate some more. They, according to the prosecution, all 3 failed to check a box to indicate Laquan McDonald was trying to flee police before he was shot. They could have marked that down in the reports, but all 3 didn't.
Right. I think that's significant, and especially when you look at that in conjunction with the video that Law&Crime has certainly talked about and shown, because it doesn't appear as if he was fleeing.
Okay, let's take it from the other side, though, right? So if you're James McKay, you're representing David March. He said his client was just a reporter that night, and he took down witness statements even if he didn't believe them to be true. So one of the questions I've asked from the very beginning, is this just sloppy police work, or is this really an intentional cover-up? Because how do you separate between officers who are like, I'm just not going to ask further questions, I think I know what this happened this night, and then other officers who are like, no, I saw what happened, I want to make sure he doesn't get in trouble, meaning Jason Van Dyke?
Well, I think that it's okay to hear that they've written down statements as they were made to them. And so that's police work. You write down what people tell you, what witnesses tell you, and you include that in your report. But in this particular case, when you take that in conjunction with an officer who testified that March said things to her and that he misrepresented things that she did and didn't say in her report, that's when it becomes an issue.
Okay, well, we're going to talk more about this police cover-up trial. Let's take a break. When we come back, though, we are going to switch our focus and talk about Jeffrey Epstein. We'll be right back. Okay, let's talk about this. Back here with Judge Ashley Willcott. We should be applauding him, not second-guessing him, referring, of course, to Jason Van Dyke.
So let me play devil's advocate. If Gallagher, when he wrote this, didn't have all the information, didn't have the video, was only listening to what he'd been told, if his perception was, listen, the person who was shot was actually committing crimes and going after the police officers, and the police officer did what he was trained to do, which is shoot because of the threat, and had to shoot to protect himself and other officers, then he may have been justified in making the statement, not to say he should be applauded, that's a little overboard, but to say he did what he was trained to do.
Let's take a step back, though. Can we all agree that based upon the judgment in the Jason Van Dyke case, he committed a murder, right? I mean, this was not a proper use of force. So
Correct.
Is the Chicago Police Department here, are we either saying that there were parties who tried to cover something up, they were so quick to say that he was in the right, or is this sloppy police work? In other words, they can't have it both ways. They can't not be a cover-up and not sloppy police work when the facts and what they're stating are simply untrue, correct?
Right. I agree with you, Jesse. I think it is one or the other. Now, again, I do keep, as a judge, I see the chaos that ensues when there's a shooting, and especially a police officer shooting. So certainly there is a lot of chaotic activity, different perceptions. But that does not justify either of the things you just described, whether it's sloppy police work, not reporting everything correctly, completely, writing it well, whatever the reasons or things are, or it was intentional and said, listen, he did use excessive force, so we're going to make our reports read differently to protect him, which is conspiracy and cover-up.
And listen, it's not easy being a police officer and working in the Chicago Police Department. You can only imagine, but I guess really what this case and this whole saga can teach everyone about really what the right protocol is, what can we learn from this whole saga. That becomes the whole question. Judge Ashley Willcott, I know we have to sign you off. Thank you so much for staying on, and we can't wait to have you back and have you here hosting.
Great. Thanks, Jesse. Have a good one.
You too. All right, everybody, let's take a break. We'll be right back.